Hemalata, madam.
Yeah. Good evening, one and all. I've been interested by the Madras Tax Bar Association with the pleasant duty of addressing a welcome to a distinguished panelist on the topic. Tribunalisation, a product of backlog and delay in courts. The topic for today is a subject that has been deliberately discussed both inside the court as well as outside the court. Has invited a cantina of decisions from Honorable Supreme Court. As the adage goes, justice delayed is justice denied. The concept of tribunalisation in India, brought about by the Constitution 42nd Amendment Act 1976 by introduction of the Article 323A and 323B of the Constitution. As we all know that the primary aim was to offload the burden of the Constitutional Court by addressing the grave concern of the backlog of arrears in specialized matters which consumes lot of judicial time. As the grave concern has been taken care of, that is the moot question for deliberation today. But we can only fondly hope that the time to see the light at the end of the tunnel is not far off. To address the same, today we have two distinguished personalities who time and again leave their imprints by way of their lucid and most amiable approach in their judgments. My Lords, Justice Rajiv Shakdher, Judge, now Delhi High Court, formerly Judge, Madras High Court. We welcome your Lordship on behalf of Madras Tax Bar Association. I can say that we are thrilled to see your Lordship would be a statement, understatement. But we are excited and enthralled by your Lordship presence. We the tax bar have fortunate enough to spend considerable time in your Lordship court, both sitting as a single as well as in the division bench. A huge learning experience for which we remain indebted. My Lord's quick grasp on the thought process and the issue involved in the cases presented before Lordship has always left us wonderstruck. The Lordship transfer did fill us with indelible sense of loss, but we are hopeful that we still left a few memories that your Lordship carried to the Delhi High Court. Welcome once again, my Lords. Can I say that my Lord's second home?
Yeah.
And I take this opportunity to welcome my Lords, Justice M. Sundar, Judge, Madras High Court. His Lordship has been an epitome of a dignified presence in wherever he presents, be it inside the court or outside the court. My Lord is a stickler for court discipline and a trident disciple of the most revered tradition of Madras High Court. After the inception of the commercial court, my Lord has been a constant influence in the betterment of the same. We at the tax bar had the good fortune of my Lords sitting briefly in the tax bench and considerably in the writ court. We are witness to some of the most flowery language of your Lordship in prose and poetry by way of judgments rendered. Your Lordship latest decision in Harivardhan versus Nitan Creative Solutions rendered on 17/3/2020 throw light on the aspect of fidelity in the judicial approach with particular reference to the Roger Matthew case and tribunalisation. My Lords, I take this opportunity to welcome both of you for having accepted for our request for today's session. And also, I'm thanking my Lords by sparing your valuable time. Today we have two moderators for the day. My learned friends, Mr. Saparna Nandakumar and Mr. Nadarajan, who will carry out the entire session today. With this, I welcome you one and all. My hearty welcome to all honorable judges and the learned members of the tribunal, senior counsels, and all participants all over India. With this, I deem it as a privilege and honor to invite my last Justice Rajiv Shakdher to take the floor.
Can I just make a little change while I accept the moderator's direction and you people are having full autonomy there. But Justice Sundar, who likes to open the innings, I would call upon him to first open and then I will follow, because let's turn the tradition around a little bit and give Madras the first chance, followed by former Madras judge the second chance. Okay?
Yes, I invite.
For the moment, I'll do some wicket keeping while Justice Sundar bowls his in swingers. Okay? Justice Sundar, good to go?
Thank you, Justice Rajiv. Very kind of you. Hope I'm only happy I'm not at the wicket. Otherwise, I would have got behind. That's very nice of you. Thanks, Hemlata, for the kind words. With regard to, I would just open with a formal address. Honorable Justice Rajiv Shakdher, host Madras Tax Bar. Ladies and gentlemen, good evening. And the honorable judges who have tuned in, who have joined this discussion, thank you very much. Very kind of you for having taken time off and have joined us. Now, this topic is tribunalization, a product of backlog and delay. I would ideally call it a theme rather than a topic. The reason why I would choose to call it a theme is this subject is inextricably intertwined with so many other doctrines, principles, constitutional concepts, starting from separation of powers, role of higher judiciary, hierarchy of courts, importance of independence of adjudicatory bodies in a functional democracy, what should be the constitution of a tribunal, so on and so forth. The list is endless. What I've given you is only illustrative. Now, all these concepts, doctrines, principles are dovetailed with something very basic and administrative, like the infrastructure for the tribunals, where would the building be, how would be the staff recruited, and these kind of mundane issues. Therefore, if you look at it, the spectrum is very broad and it is kaleidoscopic, if I may say so. It is so kaleidoscopic that it is from the doctrine of... I think there is some... I think there is some audio.
Please take care.
Yes. Can I continue?
Yes, my lord. Yes.
Yes. If you see, it's so kaleidoscopic that it is from the doctrine of basic structure of constitution to brick and mortar structure, if I may say so, namely the building and where the tribunal should be situated. But that is the reason why I chose to say this is a theme for discussion than a topic for discussion. Now, all this in the subject converges on one constitutional mechanism. That one constitutional mechanism on which these converge is transfer of judicial power by legislation. When we are talking about transfer of judicial power by legislation as a constitutional mechanism, obviously we are talking about transfer of judicial power from courts to tribunals. Talking of tribunals, as Hemlata in her introductory address mentioned, all of us look at 42nd Amendment to the Constitution, 1976, and Part 14A, which consists of a short part consisting of two articles, 323 capital A and 323 capital B were brought in. I'm not going to dwell much into this. All of us are aware of all that. One provides for administrative tribunals, the other provides for other kinds of tribunals. But with a caveat, the courts have said these two articles in this short part, the part is captioned tribunals, part 14 capital A. What the courts would say is the power to establish tribunals is in any case There in Article 246, read with the relevant entry in the appropriate list in the 7th schedule. We will just go to that. But as we go along, we'll just go to that. But what is of very, very significant or significance, if I may say, is the SOR, Statement of Objects and Reasons, which brought in this. To the extent I could dissect, it is twofold. And it is twofold in this manner. One is reducing the mounting arrears in high courts, and two is securing speedy disposal of 3 categories of cases. Those 3 categories of cases are A, service, B, revenue. Incidentally, the revenue bar is the host, and C, certain other categories of special categories of cases pertaining to socio-economic development. These are the 3 categories. And now when this 42nd Amendment in Part 14A was put in place, the basic outline was like this. Article 136 preserved, Articles 226, 227 modified. Now this led to a series of constitutional challenges and a series of case laws, a catenary of case laws, if I may say so. And here, allow me the luxury of being a little, a tinge of pride. Allow me the luxury of a tinge of pride. The reason is lion's share of contribution to growth of jurisprudence in this area has come from Madras. It's come from the Madras bar. Name it MBA 1, challenge to NCLAT, MBA 2, challenge to NTT, R. Gandhi versus Union of India, L. Chandra Kumar, and most of all, the contribution from bench has also come. Shamnad Bashir case on IPAB was rendered by a division bench of the Madras High Court by Justice Kaul as Chief Justice of this court. Therefore, even the bench's contribution is there. It's not just the lion's share. Not a single case law can be referred to without the contribution. At the risk of sounding a little boastful, I allowed myself this luxury of being a little bit of pride on this as I was part of this part. Now, coming back to the case laws, as I see it, the case laws span over 3 decades and 3 years. I'm not going to take you through each one of the case laws and the principles. All of us are very well aware of it. What I'm going to do is case laws in this jurisprudence spanning over 3 decades and 3 years, namely 33 years, from December of 1986 to November of 2019. I'm talking about S.P. Sampath Kumar on 9/12/1986 to Roger Matthews in 2019, November of 2019. What I'm attempting to do is decode the jurisprudence and codify it. In my comprehension, I find that 6 principles emerge. I place it before the House for the consideration. It's open to anybody to add if there are other principles which emanate from this. The 6 principles, I would say that and then conclude with my concluding remark. I'm looking at the clock also. The 6 principles are like this. 1. Part 14 capital A, consisting of Article 323 capital A and capital B, 323 capital B, are only enabling, as I mentioned earlier. 246, read with the relevant entry in the appropriate list in 7th schedule, gives the power. Now, what buttresses this is, being a tax bar, the earliest tribunal was much before Part 14A and was even before the Constitution. 1941, we had the Income Tax Appellate Tribunal, even pre-Constitution. Besides this, there is only one other tribunal which I am able to see, that is the National Industrial Tribunal. These are the 2 tribunals which were there even before Part 14A. This buttresses that 14A is enabling. This is principle number 1. Principle number 2 would be transfer of judicial power by legislation is permissible, but with certain restrictions and with certain caveats. The caveats have been laid down in the case laws. And this is probably traceable to Sampath Kumar. All of us know Sampath Kumar was revisited in Chandra Kumar 7-member bench, and then two subclauses were struck down. Nonetheless, this is the principle. Now, the third principle is relatable to two, is more like a corollary to this. While transferring power, the powers of the High Court have to be preserved. This is the reason why in L. Chandra Kumar, subclause 2D, 323 capital A, and subclause 3D of Article 323 capital B were struck down. Powers have to be preserved. And then principle number 4 would be, while transferring power, all the salient characteristics of a court have to be preserved. This you will get it in the challenge to NTT, the MBA matter, challenge to NTT 2014-10 ACC, page 1. And principle number 5 is more in the nature of what we are gravitating towards, as you will find in Roger Matthew, one of the honorable judges, one of the authors had said, we may be looking at an independent overseeing body on the UK model, on the English model. This is what we are looking at, as you will get from Roger Matthew. This is principle number 5. And the last principle is, maybe we are revisiting several aspects. This you will get from Gujarat Urja Vikas Nigam. The citation is 2016 9 SCC 103. This arose out of PPA, Power Purchase Agreement, Electricity Tribunal, and then it traveled to the Supreme Court. And one of the honorable judges of the Supreme Court requested the Law Commission to make recommendations on 5 aspects. One is residuary, so effectively 4 aspects. If you just look at, quickly run through the aspects, it said changes in statutory framework regarding appointments, whether it is permissible to routinely permit these appeals on substantial questions of law in the superior courts, and then whether a direct appeal to the Supreme Court is permissible, and whether that would affect access to justice, considering the territorial width, and then the exclusion of all courts without alternatives at the grassroots level, like the TDSAT, and the last one was any other recommendation. Therefore, recommendations have been sought from the Law Commission in this Gujarat Urja Vikas Nigam. This broadly is how I would decode and codify as 6 principles the jurisprudence over 3 decades and 3 years in this area. And then international scenario, I think if we will, when we go to the discussion part, I don't want to take too much of time on that. Probably when we go to the discussion part, subject to what Justice Rajiv Shakdher has to say, we will go into the international scenario. I reserve it for the latter part if it is necessary. And then we are also looking at this constitution of the overseeing body. There is even a suggestion made in Roger Matthews, which said 3 Supreme Court judges sitting, 2 Chief Justices chosen by the Chief Justice of India, and 2 from the government with the consent of the CJI, and 2 independent members. This is even the composition has been suggested in Roger Matthew, if you look at it as far as the independent oversight body on the UK model, which probably we are gravitating towards, is concerned. Now, without going into the international scenario, I would conclude with one very, very interesting aspect I noticed. Normally, when we try to find out what is a tribunal, 2 case laws come to our mind. Jaswant Sugar Mills and Associated Cement. All of us know that 1963 and 1965. Jaswant Sugar Mills and Associated Cement. We look at to find out what a tribunal is. What I did was, I tried to find out the dictionary meaning of two terms, namely tribunal and court. I looked up the Concise Oxford Dictionary, 5th edition. Concise Oxford Dictionary, 5th edition is 1963. A very interesting aspect throughout. Tribunal, the most relevant meaning is judgment seat, seat or bench for judges or magistrates, and court of justice. Likewise, if you look at court, the meaning of court is assembly of judges or other persons acting as a tribunal. Acting as a tribunal. So this was very interesting. If you look at the dictionary meaning of from the Concise Oxford Dictionary way back in 1963, and of course the school of thought that all courts are tribunals and the reverse or converse may not be true is always there for discussion. And thank you very much for letting me have the first strike, Justice Rajiv Shakdher. And now that's my concluding remark. We would wait to hear the other panelists, please. Myself. I would mute myself.
Hemalata madam?
I would mute myself. Yes. Audio.
Thank you, my lords. Hemalata madam?
Yes. So now I invite Justice Rajiv to take the floor now.
1 minute, my lord. Before your lordship could kindly begin, there were some instructions to be given to the audiences, which should have been done earlier in the beginning. Yeah, I request Prithvi to kindly give that instructions before your lordship can proceed. Prithvi?
Thank you very much, sir. So good evening to all the participants. So there are a few instructions to all the participants before we continue with the meeting. So your mics will be kept on mute for the entire session. So I request all of you not to unmute yourselves, and always keep your cameras also off so that we have a better bandwidth. If not, there will be disturbances in between. And I also request all the participants not to put up any questions in the main chat box. If you have any questions, which if we take up at the end, depending on the time available, you can put the questions to either Natarajan sir or the host Raghavan sir. So with this, these are the few things I request the participants to kindly keep in their minds. Now we can proceed with this thing. I request Honorable Mr. Justice Rajiv Shakdher to commence with his session. Thank you very much, everyone. My lords.
Yes. Thank you very much. Good evening. And since we are largely addressing a Madras audience, Vanakkam. First, I must begin with the preliminaries. Honorable Mr. Justice M. Sundar, Honorable Mr. Justice R. Subbu, and all other colleagues on the bench, if they are tuned in. I can't see them, but my greetings to them. Ms. Aparna Nandakumar, Mr. Natarajan, Ms. Hemlata, Mr. Sundar, Mr. Raghavan, Mr. Prithvi Chopra. Let me just digress a little because it is like a virtual homecoming for me when I connect with Madras. So let me commence by saying that not only am I grateful, but I am deeply touched with the connect that you have tried to make with me in this period where everyone is homebound and has no physical contact with each other. I must say, in the 12 years that I have spent as a judge, which seems like a long journey to me, the 20 months that I spent in Madras are perhaps the most beautiful part of that journey. The reason I say so are several, but me only say two things. First was the warmth that was accorded to me by the members of the bar, as also my colleagues on the bench. Second is the opportunity that I got on the bench, which was much quicker in pace than I would have got if I was in Delhi during that period. With nearly 32 districts, which is 3 times the number of districts that we have in Delhi, I could paint, or I must say it is available to every learned member on the bench, a much wider canvas. In the process, I gained not only on the judicial side, but also on the administrative side, experience, which is something that, as I indicated above, here and before, could not have been gained by me if I was still a judge of the Delhi High Court. To cite a couple of examples of the work that I could do with the help of my colleagues on the bench and members of the bar, are 3 examples that come to my mind. One is the digitization center that we set up in the Madras High Court. To my mind, that was beginning of technology in a big way coming into Madras with a baby step. Second was the setting up of a child-friendly court in Madras High Court. We had in fact intended at that time to take it further and have a child-friendly court in every district which is under the jurisdiction of the Madras High Court. The third important administrative endeavor that one undertook, again with the help of my colleagues on the bench, which includes Justice Sundar, is the amendments we try to bring about in the arbitration rules. I was fortunate to have Justice Sundar with me both on the administrative side and unfortunately briefly on the judicial side. Members of the revenue bar would know that Justice Sundar and I sat practically for a year, for a week out of the 10 months or nearly a year that I spent on the revenue bench. And interestingly, during that 1 week, I recollect asking him to write a judgment on Section 54 of the Income Tax Act. In a lighter vein, Justice Sundar, to begin with, was a little hesitant. But if you read the judgment, I think he did a remarkable job as compared to, people who have spent several years doing income tax and sometimes are not able to express themselves as well as Justice Sundar could, even though he had not been part of the income tax, the revenue bar. That being said, let me just come to the topic that we have at hand, which is tribunalisation, a product of delay and backlog. The topic, to my mind, speaks for itself. Why did we end up having so many tribunals is a question that keeps coming back to us. The obvious answer is that somewhere the court system went wrong, and it went wrong long ago. Delays and the backlog created a vacuum which allowed dispensation after dispensation the opportunity to fill the vacuum. To my mind, as someone rightly said, that there is no vacuum in nature, and therefore there is no vacuum in the judicial stratosphere as well. The history of this piece of legislation, both on the constitutional side and if you look at the statutory history, would tell you something that Justice Sundar also pointed out in the opening, goes back to a pre-independence era. There was the Rankin Committee, which gave its report in 1924. The mandate of the committee was to inquire into the reasons for delay and suggest ways and means of removing delay in litigation or prosecution of litigation. Then, of course, as Justice Sundar pointed out, came about the setting of the Income Tax Appellate Tribunal in 1941. But things, to my mind, didn't go that bad as they went bad, it appears, somewhere around 1975. Why do I say that? It is my belief as a judge, having spent more than a decade on the bench, that judgments are a product of the space and time in which we live. So judgments, as in judicial decisions, judgments of the dispensation on the administrative side are always a product of the time and space in which we live in. So 1975 to 77 was a turning phase for the country. Because it was a turning phase, an attempt was made to cede some powers from the court and vested in tribunals, which were predominantly, in a sense, manned by people from the executive. When that happened, you had the 42nd Amendment. 42nd Amendment dealt with a lot of things, most of which were effaced when there was a change in dispensation with the passing of the 44th Amendment. But what interestingly got retained was the recommendation to introduce Article 323A and 323B in the Constitution. It appears, therefore, that whichever is the dispensation, the tension between the judicial wing of the judiciary and the executive will remain. I mean, if, and I'm being a little candid here, if judges, with the assistance of the members of the bar, are not able to come up to the expected level or able to provide the kind of service that a common litigant accepts, there will be filling up of that space by having tribunals. So Article 323A and B remained. There was a challenge. And interestingly, if you read the judgment very closely, the judgment in the case of Sampath Kumar, which is one of the first judgments which dealt with this issue, there was in fact no argument or challenge to Article 323A and B. What the bench did, and the bench comprised of Chief Justice, the then Chief Justice Bhagwati and Justice Ranganath Mishra, was to suggest, so to say, repair work to the legislation, which was the Administrative Tribunal Act of 1985, so that it meets with the requirements which the law expected, the minimum requirements, i.e., if you transfer power from the High Court to a tribunal, then it should at least superficially have a setup which, even though an alternative mechanism, as they put it, supplements the High Court. But if you go back in history, you would find that it, in fact, as a matter of fact, started a little earlier, immediately after our independence, in 1956, when the first law commission, which was presided none other than by the eminent first Attorney General of our country, Mr. M.C. Setalwar, in their 14th report, it seems after much discussion with a heavy heart, they agreed to setting up of an administrative tribunal, which again, as I said, I just went back a little, came about in 1976. The reasons given were, which show the failure of the court system in that sense, the reasons given were speedy disposal, cost effectiveness, filtering of frivolous litigation, and ready availability to the superior courts of a reasoned order. The problem, however, with the amendment which was brought about in 1976 in the Constitution was they took it a step further. That's why I say if every decision, whether of the judicial wing of the government or the executive wing, is a product of space and time. The problem was they tried to take away the power of the high courts under Article 226 and 227 of the Constitution. It is then that the bar awakened to the reality that we may end up in a situations that the high courts, which are part of the regime of superior courts of this country, may be completely defanged. Defanged not, and when I say use the expression defanged, defanged not for themselves, for giving robust relief to a common litigant who doesn't have the wherewithal that someone who is higher up in the social ladder and therefore can afford expensive legal assistance. The court in Sampath Kumar really didn't deal with this aspect of the matter. What happens when you take away the power of the High Court under Article 226 and 227? The repair work, if I may say so, was done by a 7-judge bench in L. Chandra Kumar. And something that I didn't know when I came to Madras, I got to know that actually this is a gentleman who is someone who is in Madras. And correct me if I'm wrong, one of you can tell me a little history about Mr. L. Chandra Kumar, that he is actually a resident of Chennai and perhaps is a practicing advocate in the Madras High Court. But the fact remains that the Supreme Court realized that you need to retain the power of the High Courts under 226, 227, and they did not, in a sense, conjure up new law. They only went back to precedents in Keshavananda Bharati, in Minerva Mills, and then said that every decision of the Central Administrative Tribunal is liable for challenge before the High Court under Article 226. However, it will go to a division bench. So this, let's say, guarding of the turf for the common litigant continued. But what the court could not, perhaps in the constitutional scheme that has evolved over a period of time by interpretation or otherwise, was that some matters or some jurisdictions can actually be housed in tribunals other than high courts. In fact, there was a reference to a subclause of Article 32, which very interestingly says even the Supreme Court's power can be vested in some other court, body, etc., etc. So the situation that we are faced with, and there have been several decisions, is that the bar constantly, whenever there is an attempt, whether it was when the Central Administrative Tribunals were formed, or thereafter when the NCLT and NCLAT were formed, is to preserve this power of the High Court. And therefore, you had the R. Gandhi case, you had Madras Bar Association, round 1 and round 2. R. Gandhi case dealt with the Companies Act 2002. Then came the 2013 Act. You had Madras High Court Bar Association, round 1. Then you had the National Tax Tribunal. Now, the interesting part of the judgment of National Tax Tribunal is it actually agreed with the bar there. However, when we went to Roger Matthews, there was again, in a sense, I don't want to get into details, a change of perception. More recent inquiry would suggest that there is again, in a sense, some kind of asymmetry. Why do I say that? I say it in the context of the Armed Forces Tribunal. When the Armed Forces Tribunal was constituted, the challenge was made in the Delhi High Court. The judgment of the division bench was reversed. The Supreme Court, if you look at two recent judgments, while sticking to the position, because L. Chandra Kumar is the largest constituted bench on this issue, says that 226 and 227 form the basic feature of the Constitution, and if you take it away, then of course you would be impinging upon the basic structure doctrine. Said while that can't be tampered with, but since an alternate remedy by way of an appeal is provided to the Supreme Court, the High Courts ordinarily should not interfere in the matter. So this was a judgment of the Supreme Court very recently, a couple of years ago, in Union of India versus Major General Krishnakant. And in 2020 comes another judgment of Justice Deepak Gupta and Justice Anirudh Bose in Balakrishnan's case, where they have tried to again go back perhaps to L. Chandra Kumar, where they have said, well, if the High Courts choose not to interfere in a writ petition, that is only a rule of prudence and not the rule of law. They've also gone on to say that a statutory appeal to the Supreme Court is an expensive. Sorry, are we there or have I lost you? Is an expensive foray for a litigant. And therefore, the power of the High Court under Article 226 and 227 and the right of a litigant to approach the High Court cannot be whittled down. They cited the example of a junior officer or a non-commissioned officer who would find it very difficult to go to the Supreme Court. So what do we have at the end of the day? I will just sort of wind up because we are on the... We have the concerns of the bar that if there is a constant erosion of the powers of the High Court under Article 226 and 227, by taking away bit by bit every jurisdiction, whether it is in the matter of company law, whether it is in the matter of competition law, whether it is consumer courts, whether it is courts dealing with energy disputes, IPR disputes. At the end of the day, are we just are we hollowed out, to use that expression? And therefore, what is it that the High Courts are supposed to adjudicate upon? And coupled with that, when you have statute after statute bypassing the High Court by providing an appeal directly to the Supreme Court, to my mind, it does two things. It adds unnecessary burden to the Supreme Court. Two, it adds to the cost. Three, it makes justice in a sense inaccessible because every person cannot in the first instance come to the Supreme Court. And four, what L. Chandra Kumar said applies even today, which is if you have the judgment of the High Court then the Supreme Court gets to filter frivolous cases which it need not entertain. To sum it up, in my view, the Parliament, the executive, and the judiciary need to dive deep and consider whether tribunalization is actually hollowing out the high courts of something which the constitution makers had in mind. We will expound on it as we go on, but these are my initial thoughts.
Thank you, Lordship. You set the tone for the topic in a right manner. So, when Article 323A and 323B was introduced with a lot of fanfare, saying that these tribunals will be solving the problem of delay, the backlog, and it will make justice accessible to everybody, there were a lot of hope. And when those provisions were challenged, not all the provisions, some of the provisions were challenged in the first case of Sampath Kumar, the Supreme Court came to a conclusion, even though judicial review is a basic structure of our constitution, and you are depriving a person. See, when we quote Dr. Ambedkar, he said, if at all there is one provision in the constitution, which is the heart and soul of the constitution, it is Article 32. It is the writ power of the Supreme Court. And if Article 32 is the heart and soul, and Article 226 is also no less. But 323A and 323B gave the power to the state legislatures and the parliament to even oust the jurisdiction of Supreme Court under Article 332 and High Court under Article 326 and framed the provisions for the tribunal. But still, the Supreme Court did not find fault with it. What Supreme Court said in Sampath Kumar case was, even though judicial review is a fundamental feature, if you are taking it away from the High Court and placing it in a different institution which is as good as High Court, we cannot find fault with it. That was the observation in Sampath Kumar. But over a period of time, a long journey, a lot of experiences have been gained over a period of time. And finally, after some 10-15 years, when the matter again reached the Supreme Court had to turn around and say in Chandra Kumar. In fact, in Sampath Kumar, the court said the tribunals are substitutes to the High Court. But in Chandra Kumar, the position has turned out to be the High Court cannot be called as a substitute of High Court. After all, it can only be supplemental to the High Court. There is a big turnaround over a period of journey that has also been justified by the 7-judge bench after seeing the working of the tribunal over the past 15-20 years. So, what has been started with a lot of hope by way of 42nd Amendment, over a period, that particular institution has been still lacking on many aspects. So, what would have been the reason? So, this question is not to any particular lordship. This question is posed to both of you, your lordship. Both of you can answer. And then we will move on with our next question. And my friend Aparna also will be joining. So, my first question will be, what has been created with lot of expectation, even though the Supreme Court is also convinced that the tribunals are here, which are a substitute to the High Court. Subsequently, it has to change the stance and say that they are not substitutes, it is only supplement. Where do we fail? What has happened? Why the tribunal has not been able to live up to the expectation when those articles were introduced? Lordship.
Justice Sundar, do you want to go first and then I can join in?
No, I think, you should go first.
Yeah, okay. Mr. Natarajan, see, as I said, tribunals, the way the provision for the tribunals was introduced had an history and a background. But having said so, it appears that tribunals are here to stay, because this is a phenomenon which is not only prevalent in India, but it is also prevalent world over. I'm not going to get into the comparison between how it is operating in other countries like France, UK, Canada, and Australia. But in India, if tribunals are set up for various jurisdictions, apart from what I said in the opening, what needs to be ensured is that you have, along with a judicial member, for it to function properly, along with a judicial member, a technical member of that domain for which the tribunal has been set up. And when I say technical member, I do not mean retired bureaucrats who may have worked in an administrative ministry concerning that area. Say you're in the Department of Company Law, but neither as a student nor in your service would you have dealt with the nitty-gritties of the law. And merely because you've been there for 15, 20 years, you could be appointed as a technical member. But technical member, I mean, you have to give opportunities to chartered accountants, to lawyers, and company secretaries who have the domain expertise. You have to invite them to be members of those tribunals, give them good salaries, give them, protection of tenure. And then again, when you have a judicial member, you cannot have a judicial member who all his life has done service law to sit on a tribunal dealing with company law. The problem has been that you are trying to convey that you are taking away a part of the jurisdiction of the High Court because the High Court is not able to deal with it. The understated principle is that the High Court judges do not have that expertise. That's not articulated because it's perhaps not polite to do that, but that is the underlying principle. If that is the principle, you need to have domain experts. One, two, you need to, in a sense, cut them away from the executive completely. Something that was brought up by Justice Sundar briefly in his opening, which the judges of the Supreme Court also, and Justice Chandrachud has said in Roger Matthews, and other judges have been saying for a long time, right from L. Chandrakumar, that you need to have an oversight body which has got nothing to do with the dispensation. Because how do you ensure, tribunals to work in a fair and an independent manner, just like the High Courts? You have these two important factors put in. That means, insofar as their pay, their salary and perks are concerned, insofar as their infrastructure is concerned, they should have complete sway over them. Of course, with an oversight by an independent body comprising of outside experts, people of eminence. Otherwise, it is no better than just having a parallel setup where arrears will count. That's my brief answer.
Yeah, Lordship Sundar, Jay, would you like to add on this particular point, sir?
Just one point to what Rajiv had said. As between, if you see, as between Sampath Kumar and Chandra Kumar, Sampath Kumar was in 1986, and then there were as many as 5 to 6 judgments which are referred to as post Sampath Kumar, which led to Chandra Kumar. So that would be the trajectory which you opened today with when you said this part 14A was brought in with a lot of expectation, and whether it would be supplementing the High Court or whether it would be a substitute. And then, of course, 7-member Chandra Kumar came in. This subclause 2D, 2 delta of 323 capital A and 3 delta of 323 capital B were struck down. Insofar as it takes away the powers of this higher court. That is one point. The second facet of it is with regard to the members, and more particularly those with domain expertise and tenure. There is one school of thought that if the tenure is very short, you may not attract the best of the talent. This is a school of thought which is emerging. So probably we may have to look at it from that perspective also. And the last facet is what extent would be the judicial review of the higher courts qua the tribunals. That would be the, and as far as independence is concerned, I think independence of the tribunals is absolutely imperative for a functional democracy, and this overseeing body, which is completely independent. Even the composition I mentioned earlier about the composition also, that is something which is imperative. And it has been stressed by the Supreme Court, one of the honorable judges in Roger Matthews, which I think most of you would have gotten to read. Just in case somebody needs the reference, even in Roger Matthew, only one point I would just highlight. If you see there, sections 158 to 182 of the Finance Act 2017 were under challenge. Actually, in pari materia, effectively about 25 tribunals, the various in pari materia changes were brought in. But ultimately, what was interfered with was the delegation under section 185. It is excessive delegation to the government. That is where this independence factor, which we are talking about, comes in. The delegation under section 185 to the government was the one that was ultimately struck down. And as far as this observation in Roger Matthew is concerned, if you see, there was a concept given by the amicus, and the Supreme Court accepted that. And talking about National Tribunal Commission as the oversight body. And I did mention about the probable suggested composition also, which the Supreme Court has suggested. Much about the independence part of it. This is all that I wanted to add.
Thank you. Thank you, my Lordship. Your Lordship has rightly pointed out that in the Roger Matthew, if you see that excessive delegation, whether it is a qualification, tenure, everything has been left to the executive, and the act was it's a complete delegation. Thank you, Lordship. Now, I move on to my colleague, Aparna. Aparna, would you like to ask
yes,
a particular question? Yeah.
my lord. In fact, your lordships have set the stage for my next question. In Roger Matthews, your lordship had rightly pointed out that there's a passing reference with regard to the scope of judicial review. There is one reference which says that judicial review should be very minimal. It should be very strictly viewed, and it should be that of it should be adopted from the changing trends in the US, which is that of regulatory deference, so that the independence of the tribunal is preserved. Now, we have so many judgments talking about the superintendence of the constitutional courts. Now, is this possible in the Indian conditions based on the number of judgments that have come in? Whether this judicial review, the scope can be minimal, which can be termed as regulatory deference, would be my question to the honorable panel.
Yeah, Aparna, this question is to me or Justice Sundar?
Lord, to the honorable panel, my lord, your lordship, both
okay.
Answer on that.
Okay, Sundar, should I go first? Or?
Yes, please. Yes, please.
Okay. Aparna, the short answer to your question is this: that this expression, even though very attractive, deference to regulatory decisions of the regulatory tribunals, is nothing new, because, as you know, when the High Courts exercise powers under Article 226 and 227, the thumb rule or the yardstick adopted is very is set in stone almost, which is that you look at the decision-making process and not the decision. Now, which means you give preeminence to the decision unless the process is flawed, i.e., a person has not been heard, the order is not reasoned, or no reasonable man would have passed such an order or come to such a conclusion. Now, if that is in any case the contours of your jurisdiction under 226 and 227, when you are examining the decisions of tribunals or regulatory tribunals, this is actually, according to me, restating the old law. The more important question is, as has been held by the Supreme Court, as I just mentioned in this Krishnakant's case, with reference to an armed forces tribunal, that even though we preserve your power under 226, 227, but we would not expect high courts to entertain writ petitions because there is a remedy by way of a statutory appeal provided, which means while the power is there, what is the High Court supposed to do with that power? But the Supreme Court seems to have done a course correction in a 2020 judgment. Justice Deepak Gupta and Anirudh Bose have said no, 226, 227 is there, and therefore, whatever is the as I would say, the scope of the power that needs to be exercised. So therefore, this deference to regulatory tribunal, according to me, not in Indian context, but in every context, would be a misnomer. There is no deference in law, but adherence to law. If there is, a decision which is a decision-making process which is flawed, the high courts should and ought to be allowed the leeway to interfere, and that is what I think litigants are looking for.
Yes. Yes.
Lordship.
I only wanted to add that this differential regulation, I think it emanated from Canada, subject to correction. And there you have a federal court below the Supreme Court, which hears the appeals from the tribunals. And it is in that context. And there is one judgment also of the Supreme Court of Canada, which says only in areas where it is not jurisprudentially explained, this differential regulation will come into play. Otherwise, where the contours and confines are well defined, the scenario would be an exercise of judicial review and the power as available to the superior courts. This is all that I want.
Can I just come in here, Sundar? One example of this deference that I want to give to the younger members of the bar, and they would have read it, is a judgment of Justice M.N. Rao of the Andhra Pradesh High Court in Sakinala, Harinath. Natarajan is smiling. I think he has looked at it.
Yes,
this judgment was delivered after Sampath Kumar had been delivered. And the Chief Justice, in a sense, or in so many words, said that the judgment of the Supreme Court is per incurium. And this view was sustained by the 7 judges in L. Chandrakumar. So, as I said, differences to law and not to tribunals and courts. And therefore, this principle I don't understand. I think it needs modification, especially, what modification? India has evolved in this field much ahead of other jurisdictions. So therefore, as long as the decision is, appealing as per the parameters of law, why should a high court interfere? But if it isn't, certainly 226, 227 should be available to the high court to interfere.
Thank you very much, Madam. But while we are talking about that, we also need to ensure the quality of the members, the appointment, the proper way of appointing the members. That is equally important, so that the tribunals render the best. So, your Lordship's take on that? How do we achieve that?
See, Aparna, I just said a little while ago when Natarajan asked me the question as to why there is delay and backlog even in tribunals. One of the reasons that I cited was the persons who are appointed, both judicial members as well as technical members. We have scores of those examples that people have been appointed to tribunals in both categories who've not had exposure to that area. It is like saying, as I gave an example, a judge who's held a service portfolio, or all his life in his bar has done only service matters. Correct? while he will be aware of general principles of law, I think the selection committee should pause and think, if I'm going to appoint him to the competition commission, this may not be the best choice. There may be people who are on the commercial side, who acted as judges on the commercial side, and they ought to be appointed. And similarly, for technical posts, domain experts, give opportunity to lawyers in that particular domain, give opportunities to cost accountants, chartered accountants, company secretaries. In fact, I would also say, just as Sundar said that, he pointed out that people said that there is this view that short service commissions, short tenure should not be there. My view is slightly different. And this is a view that I actually also hold for the High Court. It is time to have what we have in the armed forces, a short service commission, to deal with delays in the backlog in the High Court and the tribunals. People come in for a short period of time, serve and get out. You may have to find innovative ways of doing it. Like in the High Court, you could have ad hoc judges. In the tribunal, you could have short tenure posts. And you may have to tweak it and also have a certain amount of trust, or maybe give him choice that if his main area of practice, say, of a professional is in Delhi, that I will appoint you, say, in Madras, etc., etc. You need to deal with this. But you need to have domain experts. That's the only way of dealing with this.
Yes. Probably the National Tribunal Commission that is being aimed and suggested by the Honorable Supreme Court and Roger Matthew, I think should achieve this.
No, Aparna, National Tribunal Commission is like an oversight body. That means it'll sort of look at the workings of the tribunal, and whatever they want, in terms of ways and means, they will have to go through the National Commission Tribunal, so as to delink them from the executive. But we are talking about having the right kind of people at the right places. So
very important. Yes.
Yeah. So Sundar, I don't know. You want to say?
Nothing at all. I just wanted to probably Article 224 itself is a short service commission.
It is.
So that's my understanding.
Yeah. Ad hoc judges is that, but we are not exploring that. Though this idea has been there for a very long time, we are not exploring it.
Yes.
Yeah. It's a very new point. In fact, even I was thinking that giving a longer tenure to the tribunal members will definitely help in the betterment of the tribunal. But your Lordship has brought out a new theory, kind of an ad hoc arrangement. Expertise should be developed, and to avoid any misgivings, a person from Delhi, he may be posted in a tribunal at Chennai, and he will be there for around 3 years, and he will come back to the profession. It looks very impressive. But at the same time, I have my own reservations on that. Whenever a thing like that is proposed, it may also give, justice should not only be done, it should also be seen to be done. There may be a tendency, or at least people may fear, once I go back, I have to sustain in my profession. I may require the support of the government when I go back. Suppose if we take an officer on an ad hoc basis, so after he serves in the tribunal, his subsequent posting may depend upon how he has performed in the tribunal. This is the general fear among the general public. So if we engage in this short service commission format, will it not interfere with the independence of the members, or will it not create any doubts in the minds of the general public about the credibility of the institution? Rather, like institution, see the provisions, lot of reappointment provisions are there. So once there is a reappointment provision, there will always be a fear in the mind of the public. So whatever action you do in the first tenure will always be keeping in mind how to get a second tenure. So this is how to balance this two things.
Since I propose that point, let me just answer this, Nataraj. Firstly, this is not for the weak-hearted. It is for people who want to do service. Correct? Secondly, you need to find people at various age groups. If you're talking about high courts, we are already having a problem I can tell you about Delhi, maybe even Mumbai, maybe in Madras also, I don't know, Calcutta, where it is very, very difficult to get youngsters to come onto the bench because the disparity between what you get at the bar and what you earn as a judge is increasing day by day. Apart from other aspects, which is, the loss of certain amount of, what should I say, for want of a better expression, a more conservative way of living is brought about when you are on the bench. But if you get people who've earned their money and they are in the age range, I'm now giving an example of the High Court, but they are in the age range of about 55 or say 57. A lot of them who earned money, who are comfortable, they want to do a short stint for 5 years. They come in, they serve, they do their bit, and they get out. You can ensure that, say if a guy is from Delhi, he comes to Madras and goes back, and of course, he'll never be able to, he should not be allowed to practice by way of custom or otherwise. It may have to be a custom that you develop that he will not practice in the Madras side. To do away, assuage those fares. Insofar as tribunals are concerned, you may have younger lot, you may have older lot, but you can, this is something that you need to think. Do you get them to get reappointed? Because reappointment always means that there is that fear that you may rule in a particular way, but don't have a reappointment clause because that was done away in other cases also. So these are things that can be dealt with. But if you are not going to have, see, the important thing is, way back, there was a Malimat report. In fact, in that report, it was suggested that you must have divisions in the High Court and not tribunals. Commercial division, admiralty division, etc., etc. So that over a period of time, you develop that expertise in the High Court itself to deal with those matters, because that's the argument which is most potent when you need to deal with this situation of backlog and delay. So therefore, you need to think out of the box. The time is gone that you will only set up tribunals and hope for the best. It is not happening. It has not happened in DRT or a DRAT or other tribunals. So that's my take on this.
This division is working well in England, I suppose. Divisions in the court working well as a model in England.
Yes. We're almost at the end of the session. Just this final question before we wind up with the vote of thanks. Digitalization is, of course, one of the essentiality today. What other measures could your lordships suggest for an ideal tribunal? Digitization is one aspect.
See, Aparna, Aparna, if you're asking me, how should we use, basically your question is how should we use technology to up our game, so to say.
Yes.
According to me, what we are dealing with today is only automation, but not transformative technology. Correct?
Yes.
We are having a computer here,
Yes.
we are having an internet connection there, we are doing digitization. That is not transformative technology. But having said so, Aparna, that is important, because if you don't have digitization, you will not have e-filing, and if you do not have e-filing, you will not really have the kind of virtual courts we are talking about. So what are technologists looking, say in 2030? They are looking at courts which are not only doing the kind of virtual hearing we are doing. Today, what are we doing? We are actually having a VC connection, a video conference. So a judge sits at one place, lawyer is another place, we are doing that. But that is something that the corporates have been doing now for ages. We've not done something new. We've been forced to do this.
Yes.
And there has been resistance, but now we can't help it because of the pandemic. But what technologists are looking at is, and it is happening, and it will also take away much of the court work, is what is known as augmented telepresence. That means you have a telepresence room where you have a virtual hearing which almost is suggestive of the fact that the other person is sitting across the table.
Yes.
And you find no difference. So the feeling that you are not in a physical court is sought to be done away with. Now that is some years away, if not more. I don't know in India how far we'll go, but world over that is happening, where you will get the look, feel, effect, as well as the kind of participation that you have in a physical court. Because the attempt of courts has to be that you cannot but ensure when you use technology, everyone has access to court, because that's the strength of a court. If technology does not provide access to that common litigant who's in some remote corner of Madras, then that technology is useless. It should be cheap. And people should be able to look into the proceedings in the court, like you do in a physical court. You walk in, a judge is there on display, as I say, often say between 10:30 and 4:30 or whatever, 4:45. And unlike a bureaucrat, he does everything in the open, which is the greatest strength of the judiciary. So technology has to ensure that, and therefore you need to quickly adapt technology, transformative technology, and not just automation.
Yes, thank you very much.
Lordship, before we go to the one final small question, both your lordships have been having a lot of experience in sitting over appellate jurisdiction against the various tribunal orders, maybe tax tribunal, maybe other tribunals. So your lordship, both of you had a lot of opportunities. So how would you see that particular experience, the quality of orders, where they are good, where they lack? So your lordship, both your lordships kind experience on the quality of the orders which are coming before your lordships on day in and day out. Your lordship may kindly share your views before we call Prithvi.
Sundar, I think it's time you say first. I've said, then I'll follow you.
I will follow you, please.
Okay. Okay, my view is it's a mixed bag. It's a mixed bag. And the reason that I say so is there are some people, even though they belong to the civil service, who adapt very quickly. And because of their intelligence quotient being very high, and some of them are remarkable officers, they can quickly adapt to that jurisdiction. So I had this example, a fantastic example, and I don't know, I haven't met this gentleman for years when I was a lawyer. So we had this appellate authority for industrial financial reconstruction. We had this wonderful gentleman who was from the civil service, who retired as a secretary, and who presided over that. He was, in fact, better than the judicial member. And the quality of his writing and the depth and understanding was fantastic. But having said so, that gentleman may be an exception. I mean, there are not too many of them. Similarly, in the company law board, we had, I think he was the chief secretary, Maharashtra, Mr. Upasni. Another wonderful civil servant who did a fantastic job in the company law board. Then again, over the years as a lawyer, which was about 18 to 20 years, only two such instances come to mind. But that exception cannot be the rule. As I said, quality will improve if you have youngsters with 20 years of experience as chartered accountants, cost accountants who know the subject, who get onto the bench, or lawyers who do day in, day out. I'm talking about commercial law, patents, trademarks. Then there is some rationale in having these tribunals, and then what they said, filtering out of frivolous cases, and if they come to the High Court also in a 226, we'll apply the same parameters. We won't interfere with the decision. Is there anything wrong? Were you given an opportunity? Were you shown a particular document? Same principles.
Yes.
It's a mixed bag.
Lordship.
I agree, it's a mixed bag. My exposure is more 260 capital A of the Income Tax Act, which is akin to Section 100 CPC. If my memory serves me right, subsection 7 of 260 capital A, I think, says so, that all principles of Section 100 of CPC would apply to an appeal under 260 capital A. The point I'm attempting to make is, 100 CPC principles apply, you will entertain an appeal only on a substantial question of law, not even on a question of law. And what is the difference between a substantial question of law, long line of authorities are they, starting from Chunilal Mehta, long line of authorities, starting from Chunilal Mehta right up to Hero Vinod and line of authority. The point I'm trying to make is, why it is a mixed bag is, some of the orders of the tribunals which come up on appeal, if you see, they're so well written, so tight, that it's very difficult to raise a substantial question of law. Sometimes the core of the matter would have been, the pulse of the problem, if I may say so, would have been dealt with fairly well. But then there may be a gaping hole, or if I may use the expression, which provides for a good, neat, substantial question of law to be raised. We come across several orders even where all those are neatly plugged. Sometimes we do find the other end of the spectrum also. So therefore, it's clearly a mixed bag. And how you blend this when you deal with the pulse of the problem and also ensure there's no scope for raising a substantial question of law is an art by itself.
Yes.
Can I ask Justice Sundar's reaction to only one thing? This merging of 4 or 5 tribunals into one. You have the Competition Commission, you have the Companies Law, you have the Sikh Industries Act. I mean, you have to be a superstar to know all these jurisdictions. Even lawyers find it difficult. So I don't know. Is this the best way forward? Legislature needs to look at it.
Yes. Maybe this will be very apt to quote here what Ambedkar said on 25/11/1949. Because I feel, however good a constitution may be, it is sure to turn out bad because those who are called to work it happen to be a bad lot. However a bad constitution may be, it may turn out to be good if those who are called to work on it happen to be good. So the point is, constitution makers have done their best to give the best constitution to all of us. And it is for us, whether we are part of the judiciary or executive or legislature, it is for the people to properly interpret and uphold the constitution. So it all lies only with the people, whether an institution is good or bad, how it is going to be. So maybe Aparna, you have any final questions to ask, or if can we call upon any other lordship who has been attending today?
Yes.
Would they like to share any of their experience? Maybe you can call.
Lordship Justice Subramaniam, if he's there, if your Lordship is there, can your Lordship share your thoughts on this?
There,
Yes.
hear me.
Yes.
One best example of failure of tribunals is our state administrative tribunal.
Yes.
As Justice Rajiv Shakdher pointed out, we had a wonderful officer in the tribunal, one Mr. Sundar. We used to overtake the judges also. But ultimately, the tribunal failed because of various reasons. And tribunalisation may be good, but as Natarajan pointed out, quoted Ambedkar and said that we should have the best people around, as Justice Shakdher also pointed out. Unless we have the best people around, any form of adjudicatory mechanism will fail. That would be my remarks. Thank you.
Thank you very much.
Aparna, any Lordship, time is already 6:20. Shall we go for the closure, or shall we entertain any of the questions? Subject to Lordship's convenience.
No. I think we've spent long enough. People must be tired. So, with Sundar's permission,
fabulous session.
We close the session, Sundar?
Yes. Yes. Now, thank you, Lordship, for your wonderful time. You have spared a lot of time with us, both the Lordship and other judges who have joined. For everybody, I have given you a lot of time. May I now request our host, Prithvi, to come online and take the session to its logical end. Prithvi?
Thank you very much, Rajan sir. Thank you, my lords, for the wonderful session and for the discussion also at the end. So before I call upon Mr. S.R. Sundar to propose the vote of thanks, I would just want to state that we have our YouTube channel by name Madras Tax Bar, where we have uploaded all our webinars. We have been conducting webinars from April 11th onwards, and today is 59th session. So we have uploaded everything on our YouTube channel, which is named Madras Tax Bar Chennai. So all the participants can have a look at it. And I thank you once again a lot for gracing this occasion. Now I call upon S.R. Sundar sir to propose the formal vote of thanks.
Thank you, Prithvi. I'm very delighted on behalf of Madras Tax Bar Associate to propose this vote of thanks. This all began about 20 days back, and the topic was so catchy. It was suggested by Justice Shakdher when one of the members reached it. And it was the interaction was so easy with us that we did not have anything. But on the other hand, we have learnt a lot on how the other tribunals have been doing across the world. And I'm very thankful for Lordship Justice Shakdher for providing this opportunity to enlighten us. The access to justice, as well as this the burden on Supreme Court and the two-tier system has been very well explained. And I also thank Lordship Justice M. Sundar for his six principles like Six Sigma, as well as the word Oxford Dictionary, which is new to us. I thank you, my Lord, for both of your kind time and enlightenment on this aspect of tribunalization. I also thank Justice R. Subramaniam, Justice Sendil Kumar Ramurthy, and Justice Saravanan J for joining this. And I also thank other members of ITAT, CAT, and Income Tax Appellate Tribunal members who are also attended it. And I am also thankful for this event because the team has worked wonderfully, headed by AP Srinivas, Hemalata, Aparna, Natarajan, and of course, the man behind all the controlling factor, Mr. Ramabhadran and Lakshmi Kumaran, Prithvi, Nitin, and Sai Prashant. All of them did a wonderful job of coordinating with each other. We are doing lots of rehearsal. And of course, without the participation and encouragement of the members of senior members of bar, as well as the senior advocates who have participated in it, it would not have been a success. I thank you one and all, including members who are also globally watching this program. Thank you one and all. And I also thank all the technicians behind this, which we have been able to thank them because we are making experiments, how whether it's come out well and other things, it has come out very well. I thanks one and all the members, junior members who are also encouraging factors for this thing to go on. And thank you very much.
Thank you, Nandri.
Thank you. Thank you.
Thank you.
Thank you. Prithvi, you can end the session.
Thank you very much, Sundar sir. I thanks once again all the participants for joining us. We will be continuing with our regular sessions from tomorrow again. So thank you once again to the honorable judges who have joined us and to all the participants. So good night and take care, all of you. Thank you very much. I'm ending the session now. Raghavan sir.